Good evening to all of you. We all know that according to Section 32 of the Indian Evidence Act 1872, which is an exception to the rule of hearsay, it says that the evidence of a person who cannot be found, who cannot be brought back, that means who died, it can be taken into as a relevant factor provided the so-called dying declaration is recorded. You all know what is a dying declaration. Here already we told you in some number of cases that dying declaration per se cannot be the source for giving conviction, but should be corroborated by other evidence. This is the general principle. Of course, every case depends on the facts and circumstances. There are umpteen number of occasions where even the Supreme Court also held that if the dying declaration is worthy, then definitely conviction can also given. And you know that there are certain cases where even though there is a strong dying declaration, if the other facts do not corroborate, definitely they need not give weight for the dying declaration. Today we are going to discuss another point in the same direction, in the same dying declaration. Normally, you may be knowing, whenever the dying declaration is to be recorded, the so-called medical officer, he has to give a certificate that the patient is in a fit condition to give the statement. Right? Otherwise, the trustworthiness of the statement will come definitely suspicious. But Supreme Court stated that it is not necessary. Of course, here also you have to know that the facts and circumstances are based. So now, let us hear a case. This is a case disposed by Honorable Supreme Court of India, 3 judges bench. This case you can refer it as Surendra Bengali alias Surendra Singh routele versus State of Jharkhand 2021. So this has arisen out of the civil appeal number 1078 by 2010. Of course, this appeal was disposed on 4th February 2021 by 3 judges bench, Ashok Bhushan, Ajay Rastogi, only 2 judges bench, I'm sorry, Ashok Bhushan and Ajay Rastogi. Right. Here, the main contention is that, of course, the accused person, this is Surendra Bengali, is allegedly to have come on a motorcycle with some assailants, called the deceased, his name is Mr. Mahendra Pandey. In Ranchi it happened, Kotwali police station, Ranchi. So called this man out and actually hurled bombs on him on 23/7/1988. Of course, since his condition was not good, immediately Mahendra Singh he was brought to that area hospital, Ranchi, so where his statement was recorded. Of course, immediately the medical officer on duty sent intimation of accident injuries to the police as well as to the magistrate also. Incidentally, the magistrate has come earlier. After the magistrate arrived, the duty doctor stated that yes, this man is in a fit condition to give a statement. So basing on the version of the medical officer, the JFCM started recording the evidence of the so-called Mahendra Pandey, and it was completed by so and so hours. Then he left the place. Later, the police, even though they came just after the arrival of the JFCM, since the DD was being recorded, they kept quiet, and later they have actually taken down a copy of the DD from the magistrate and they registered as a case. Right? Now, this has become the sole evidence, and basing on the dying declaration, the conviction was given by the trial court. So then High Court also confirmed the same. Now it has come to the Supreme Court. Right. Now, the contention on behalf of the appellant or the accused, that Surendra Singh, is that the conviction is solely based on the dying declaration, but which finds there is no corroboration. Simply to say, which finds it does not find the corroborating certificate from the doctor. So that means the doctor did not give in writing that the patient is in a fit condition to give a statement, right? Of course, the state immediately they have retarded or they argued that such doctor certificate or endorsement of the doctor is not mandatory in all cases. Maybe necessary, but it's not mandatory because the dying declaration recording of the same depends on so many other facts and circumstances. Right now, after perusing the record, the two judges bench they stated that although the document or the dying declaration did not contain the signature of the so-called medical officer, but the evidence of the judicial magistrate who came to the court, who stood for the cross-examination and stated that the doctor told him that the patient was in a fit condition, basing on which he recorded the statement. Finish. So these facts and circumstances, they are sufficient that the dying declaration was recorded correctly without any or foolproof, right? So now the entire case is. So now the Supreme Court has relied, of course, the defendant or the appellant relied on the statement of Paparambaka Rosemma versus State of AP 1999, where the Supreme Court held that in the absence of wound certificate, it is very risky to accept the subjective satisfaction of the magistrate, right? Because it has been too broad, of course. And also the interpretation also may not be correct to depend on such a wound certificate, on such endorsement. So if the endorsement that the patient is in a good condition is not there, definitely it is doubtful. But so another case is there. In the case of Lakshman, yes, Lakshman versus State of Maharashtra 2002. So the Supreme Court itself held that the evidence depends on the facts and circumstances. Now, in this connection, I want you to take back to 1939, very famous case of Pakala Narayan Swami versus the Emperor, 1939, where the Privy Council at the time, they have clearly stated that if the statement of the deceased person relates to any transaction or the cause regarding his death, definitely it can be taken as the dying declaration. They have depended on section 32 clause 1, where it relates to cause of death, or they may be knowing clause 2, where it is made in the regular course of business. You may be knowing in this connection, Mr. Narayan Swami told his wife that he was going to Berhampur to collect the money due from that woman, Mrs. Raja of that Chhatarpur, and ultimately his dead body was found in a trunk in that some train, and first they did not identify, subsequently they identified. Only thing is, when she said that he has told her that he was going to Berhampur to collect the money and he died. And she has produced 4 letters, I think, this woman calling him to come and collect the money like that. So that was taken as the very good piece of dying declaration. So friends, remember, so in the dying declaration, normally the first point we have to think is that definitely the argument of the appellant is 100% correct. Of course, whether it is accepted or not depends on the judges also. But here we can know, we have to see that the certificate or the attestation from the medical officer at sometimes may not be necessary. Of course, since the man was a judicial first class magistrate and he has come to the court, it was accepted. But normally it may not be accepted. Anyway, it's a good judgment, worth reading and noting the points. The main point is that the attestation or the certificate from the medical officer is not necessary for giving conviction, is not necessary on the dying declaration, right? Thank you.